Hey folks, Dale Davidson here today. Thank you for tuning in. We appreciate everybody out there. So, hey look, I like to do these top 10 lists, and so today I've got this top 10 do's and don'ts in estate planning. So look, estate planning is just not just for the rich and famous, not for the Elon Musk of the world. Estate planning is for everybody, the young and the old. You certainly want to safeguard your assets and ensure that your loved ones are taken care of after you're gone. But in order to safeguard and ensure that, you got to have it in writing. That's what an estate plan is. But many people neglect this important step and make mistakes that can have, pretty drastic and serious consequences. So whether you're just starting or reviewing your plan, so here are the top 10 do's and don'ts to keep in mind. The do's first, okay? Number 1, do start early. Don't wait until it's too late. So life is unpredictable, and having an estate plan in place while you are healthy and know what the heck you're doing, okay, ensures that your wishes are going to be respected. The earlier you begin, the easier it is to adjust to life changes. I was just talking to a client this morning. Her parents were in dire straits, and so we're in a crisis mode planning, which limits what we can do, versus a proactive mode, which we have a lot of different things we could do to help preserve and protect those assets for mom and dad's health and long-term care. So do start early. Number 2, do update your plan on a regular basis. So there's marriages, there's divorces, there's births of children, there's grandchildren, acquiring new assets. Maybe say you get a beach house, but I don't know if I'd get a beach house with all these storms out there. But so look, as you grow and as your assets grow, you need to update your plan and make sure it's exactly what you want it to do. So review your plan regularly, every 3 to 5 years, or after significant life changes, to ensure that it's going to do what you want it to do. Number 3, do name guardians for your minor children. If you have young children, appointing a guardian is one of the most critical decisions you can make. Make sure to name someone you trust and who shares your values to care for your children should something happen to you. Okay? Make sure that they are a good fit. Make sure that your children get along with them. Number 4, do consider a trust. Okay? Now, we call them living trust or revocable trust. These types of trust help avoid probate. They maintain your privacy and provide more control over your asset and distribution of your assets, okay? It can also allow for a smoother transaction or smoother transition in managing your assets should you become incapacitated. So a living trust or revocable trust is a good way to help maintain privacy is a big thing for me, and staying out of the court system. Number 5, do designate beneficiaries properly. Like all things, you may have a life insurance or 401k, an IRA, or whatever the asset is, are often controlled by beneficiary designations. So ensure that all your those types of accounts or assets have up-to-date beneficiary designation. This is an often overlooked thing. I have seen where people have been divorced and they didn't change the beneficiary designation on life insurance. I saw where one gentleman he was divorced, but didn't change the beneficiary designation on his 401k. I'm quite sure that their spouse or their new spouse would be upset if the ex-spouse got that asset over him or her. So make sure your beneficiary designations are up to date. Always have a power of attorney. It's got to be a durable power of attorney. It can't be a general power of attorney. Can't be a limited. It's got to be a durable power of attorney, and it can take effect at a certain period of time, say for instance if you become disabled. But this gives somebody you trust the authority to make financial and legal decisions for you regarding your property. Power of attorney has power over your property. You're not able to make those decisions, then you have appointed somebody to do that. If you don't have a power of attorney and you become incapacitated, we're going to march down to the probate court and spend thousands of dollars getting somebody appointed as your conservator. Okay? Do plan for your health care decisions is number 7. Here in Georgia, we call it a Georgia Advanced Directive for Healthcare. Other states call them a healthcare power of attorney. They're all the same, okay? This is a healthcare proxy, a medical POA, power of attorney, that allows somebody that you trust to make your medical decisions if you're incapacitated. In addition, we can include language as to a living will. What happens if you are in a certain state? Do you want life prolonging procedures administered to you? So do plan for healthcare decisions, because if you don't have one and you can't make those decisions anymore, again, just like the conservatorship, we're going to trot down to the probate court and get a guardianship over you. And again, spend thousands of dollars doing something you could have done with a simple advanced directive for healthcare. Number 8, do minimize taxes. Do consider strategies that would reduce the tax burden on your estate. There's right ways and wrong ways of gift giving, okay? Consider charitable donations, okay? Do some kind of tax advantage accounts can help reduce taxes. I'm all about reducing the taxes. I think our government gets way too much of our money as it is, and they don't spend it properly. Number 9, do seek professional help. Estate planning is not easy, it's complex. Work with an estate planning attorney to ensure all aspects of your property, your family, your health, your well-being is covered, okay? Now they can guide you through the legalities and ensure your plan is tailored for your specific situation. And when I say an estate planning attorney, I don't mean a family law attorney. I don't mean a real estate attorney. I'm talking about somebody who does this every single day, okay? Because they're going to know the ins and outs of the proper techniques to use. Number 10 of the do's. Do communicate your plan. So communication is the key. Let your family members, your key members, okay? You don't have to let, if you got a wayward son, you don't have to let him know, but let key members of your family know, or your close friends know about your estate plan, including where am I going to keep my important documents? A lot of people like to keep important documents in a safety deposit box. I don't like that unless you have their name on your safety deposit box and they can get to your safety deposit box in an emergency or if something happens to you. Otherwise, just keep your documents where you would normally keep your important papers, in a safe place in your house. Number 1 of the don'ts. Why do it today when I can do it tomorrow, okay? So don't procrastinate. This is one of the biggest mistakes I see, waiting too long. Many believe that estate planning is for older adults or the rich and famous, but everyone benefits from having a plan. Everyone benefits from a power of attorney or advanced directive for healthcare. We have done several guardianships on young people, young adults that is, who didn't have anything. But they can no longer manage their finances, they couldn't manage their healthcare decisions, so we had to go down to the probate court and spend thousands of dollars getting that done for them. So don't procrastinate. Number 2, don't forget about your digital assets. What happens to your email, your social media accounts, your online accounts, cryptocurrency, all of that. They're often overlooked in estate planning. Make sure to include somewhere in your documentation, your login information for your email, your login information for your social media. I had a good friend who passed away about 7 years ago. I still get updates from Facebook regarding his birthday because nobody has access to his Facebook account to cancel it. So, look, just be prepared. Okay? Number 3, don't overcomplicate the process. Estate planning doesn't need to be overly complex. I mean, especially if you've got a small estate. But there are simple strategies, like just a simple will, a simple power of attorney, a simple advance directive, and beneficiary designations can cover your needs. So avoid being too complicated, okay? Number 4, don't rely solely on your will or a will, okay? Now, a will is the basic estate planning document, the tool, okay? But some assets bypass a will and go directly to beneficiaries, such as a 401k, an IRA, life insurance, those kinds of things. They have beneficiary designations. Make sure your accounts have correct beneficiary designations, okay? Make sure that everything that you have is covered, whether by the will or by a beneficiary designation. Number 5, don't name inappropriate executors or trustees. So you know who the correct executor or trustee is for you. You know, that's critical. You don't want to name a child who is a problem child, maybe has gone through numerous divorces, or who has really bad credit, who can't handle money or anything like that. So you understand who that person is. Don't name them. Just because they're a child, they may be your only child, doesn't mean that they're qualified or should be in charge of your estate. Okay? Ensure that you choose a reliable, trustworthy, and capable of handling the responsibilities of your estate and managing your estate. A lot of times courts now are requiring these executors to post a bond, and you got to be creditworthy to get a bond to be the executor of the estate. Even though the will says they don't have to post a bond, the court has the discretion to require a bond. Number 6, don't neglect to plan for possible incapacity. Estate planning is not just about somebody dying. It's also about ensuring your affairs are handled if you're unable to do so. Failing to plan for incapacity can lead to, again, a court-appointed guardianship or a court-appointed conservatorship. Then you've got family involved who may not get along, who want, maybe you got one who wants to be, who's the control person of the group and wants to control everything and leave the other people out. So look, that's why the durable power of attorney is so critical, as well as the advance directive for healthcare. So don't forget to plan for incapacity. Number 7, debts. Ensure that your estate plan accounts for outstanding debts. Now, some assets may need to be sold to cover those debts, and this can access how much is left to distribute to beneficiaries. Now, as an executor of the estate, unless you distribute something out improperly, you're not responsible for the debts. But if you distribute something out to a beneficiary without satisfying that debt or making some arrangement to get that debt paid, you could be personally responsible. So don't forget about the debts. Don't make assumptions. Don't assume that family members will know what to do and agree on everything. death and incapacity seem to change people, and then they want to control the whole situation and make all the decisions to the exclusion of their siblings. You know who that is. So don't assume that everybody knows your wishes. Communicate with them, okay, and let them know, this is what I want, this is what I'm doing, okay. Number 9, don't ignore special needs or supplemental needs. Now, a lot of people that we counsel here have children with autism, Downs, things of that nature. So they have we call them uniquely special children, okay? They say, well, I'm not going to leave anything to my uniquely special child, because if I do, then he or she can't handle it anyway, and her government benefits will be cut. Well, guess what? You don't have to leave them out. There are supplemental needs trusts that we can incorporate into your will to make sure that your uniquely special child is taken care of for the remainder of his or her life. Okay? So don't ignore their needs too. Don't think that you have to give everything to your children who don't have supplemental needs to the exclusion of your uniquely special child, because that's just not true. Number 10, my last one. Don't DIY without understanding. Well, what does that mean? So DIY estate planning, maybe tempting. Maybe I'll go to the big box store, Office Depot, and get me a will kit, or I'll go on the internet and look for these DIY wills. That's okay, but they can leave out important legal nuances that would be important to you, and making sure that your assets are distributed in accordance to your wishes, okay? So there are mistakes in estate planning documents can invalidate your plan. Maybe you don't have enough witnesses. Maybe it's not notarized. Whatever it can, there's a lot of different things that can happen that can invalidate a estate plan. So just be careful. You're better off consulting with a legal professional if you're not sure. So hey folks, thank you for tuning in. Look, estate planning is one of the most critical steps you can take to protect your assets and loved ones, okay? So by following these do's and don'ts, you can avoid common mistakes and ensure your wishes are carried out. So look, hey, check this video out, Top 10 Early Dementia Signs, Important Warnings, to give you some good tips on what to look for and what not to do if you've got somebody with dementia in your family. Until next time, have a blessed day.